Hey, I'd like to welcome you to another episode of Mission Matters. My name is Adam Torres, and if you'd like to apply to be a guest on the show, just head on over to missionmatters.com and click on Be Our Guest to Apply. All right, so today I am in Atlantic City, New Jersey, and let me tell you, I'm at the MicroCap Conference and having all kinds of fun. First time I've been to this conference in person. We've been covering it for years, and today I was able to snag a reoccurring guest, maybe next co-host, I don't know. Jacob, man, welcome back to the show.
Adam, great to be back with you, and welcome to Atlantic City for the conference.
Yes, good to see you. So,
and you in person.
Yes, there you go. I know last year you were a speaker. I think you're doing some things this year as well, and didn't make it to it in person last year, but I know we did a virtual interview, so that's what Jacob means when he says in person. So we've worked together, and we'll put some links to our previous interview in this too, so you can check it out if you just go to the website. But man, how have you been?
Doing well. Good to be here, and actually great to meet you in person, and you having a successful conference.
Well, you were on my mind. We got an
administration. That sounds like a song.
There we go. Administration change. I mean, you have a lot of history for your time and tenure at the SEC, a lot of conversation at this conference and just in general about, like, is regulation going to be lightening on maybe some of these mid-cap companies or micro-cap companies as this conference, and just the overall landscape. What can you comment on that?
Adam, it's a great question because there's a lot of anticipation, not only because we've seen so many executive orders coming out of the White House, literally with the change of administration, but the expectations around the new chairman of the SEC. What people are speculating that the administration is really going to influence the chair, but I think the best thing to do is look at what were this incoming chairman's views when he was an SEC commissioner. And I think he is going to prioritize investor protection. And I mean, obviously the SEC has three fundamental missions, but for him, investor protection is critical. And there are a lot of people saying, well, cryptocurrency, there aren't going to be cryptocurrency cases anymore. Not true. Fraud is still going to be a focus. Investor protection, in the eyes of the SEC institutionally, when it comes to the small cap, micro cap, mid cap space, it's still a mindset that it's the Wild West. So I don't think there's going to be any lightening of enforcement activity when it comes to the small cap, micro cap, mid cap market. And particularly when you start taking lawyers, staff away from working on the investigations that are focused on trying to create law through enforcement, which we call regulation by enforcement, which incoming Chairman Atkins is completely opposed to. You're going to have available career staff still looking to conduct investigations. So I do think the enforcement environment is still going to be active and robust for this space. Adam, your question also included regulation. I don't think we're going to see any regulatory changes that any way are going to particularly help this market. And I think there are some new rules that have come out of the NASDAQ. I think there are some new rules out of the New York Stock Exchange. They're actually going to make it more difficult for the small cap companies. So I really don't see any help coming. But I think we're going to see, at least on the enforcement side, a continued focus on what I would call the traditional core cases out of the regulatory enforcers, meaning fraud, anything that smacks of fraud, as well as traditional books and records, internal controls, the integrity of the disclosures that a company is making.
And you would expect that, right? It's not like all of a sudden, I mean, just logically, it's not like all of a sudden we have a new president, we have new things, so now we're not going to investigate fraud. Like, we're going to let that happen. Like, I don't know. You know what I mean?
Well, I think people want to make that assumption because of what they hear out of the White House and what they expect, particularly when it comes to the cryptocurrency, the crypto digital asset market. But even there, as I was saying, I expect the SEC still to be bringing fraud cases involving digital issuers, cryptocurrencies, because again, protecting the individual investor,
of course.
It's core fraud. So those anchors of the enforcement program, I shouldn't omit insider trading.
Of course.
But again, you're talking about fraud, insider trading, disclosure issues. Those are fundamental to the program, regardless of whether we're talking about a Democrat or Republican administration. We see these changes periodically, maybe every 4 years, 8 years. and those programmatic fundamentals will still very much be in place.
Talk to me about, let's say we're here today, MicroCap Conference. So from the standpoint of the CEO or the company, the publicly traded company, like what should they be thinking about when they're thinking about managing or monitoring, let's say, the regulators' expectations? Like, how do they meet those?
The fundamental answer is compliance. Compliance, integrity, take ownership. And what I often find, when people are coming to me because they're now in the investigation world, or even firms that are looking for what I call best practices when it comes to governance and compliance, understand the regulatory regime that you're in, because there is no greater risk to a company than to become a subject of an investigation and ultimately be named in investigation. It is very difficult to unwind that effect because there's a stigma that attaches. So I would say compliance, attention to detail, quality professional provider advisors, and understanding your obligations, your responsibilities, and play to the highest standard, not look for what can I do to get by, because that's really where the problem is going to be. And also, if an issue arises, attack it early. Don't wait for it to mushroom and become a true problem, because the cost of litigation, the cost of after-the-fact remediation is disproportionate to imposing best practices up front.
Shifting focus here slightly, some news on your end. Let's start with this one. I know I got a couple here, but you recently beat a 10-day trading suspension. Tell me a little bit about that.
Well, interestingly, that actually does tie directly to this conference, in the sense that, the SEC uses its statutory authority to impose 10-day trading suspensions if it believes that there is materially false and misleading information or possibly manipulative activity involving a small cap issuer. That 10-day trading suspension has a near fatal and typically fatal effect on a company. In the early days of COVID, when the SEC obtained, if I remember correctly, the number was like 40 or 50 trading suspensions. I was retained by a company that was in that 10-day window, and that's the key. In other words, to fight a 10-day trading suspension,
got to be in the 10.
That process needs to start within the 10 days. Don't be a deer in headlights. In other words, attack it early on. That company, and I can say it because it's all public, NanoMagic retained my firm. We were very aggressive, and literally for 4.5 years pursued the fight with the SEC. This past fall, the SEC, for the first time in its history, truly in its history, set aside the trading suspension as if it had never been put in place in the first place. So it really was
interesting. So it's wiped clean.
It's wiped clean, and now we're actually, I'll use the word suing. We have filed a statutory proceeding to try to recover attorney's fees. So is it completely done? No, but in terms of the merits, the company has been completely
and the black mark.
vindicated.
I mean, ultimately,
and the black mark. And the other thing about the black mark is once that hits at the SEC level, that will then trickle down to the OTC market too, when they put a skull and crossbones on a company. So it really does have a significant effect, impacts a company's ability to raise money. And for most companies, the ability even to survive. So I give that company a lot of credit for having had not only the foresight, but the tenacity to see this all the way through. And we knew what we were up against. The commission had never done this before. Set it aside. And we were very fortunate in that regard.
You must have been pretty confident when you even took that on, that this was a possibility, or was it like, I'm just trying to get into your head on this one, like what you can say. Like,
well, I mean, there's not much that I can't say because it's all public. I think part of it is really understanding the inside SEC baseball and how this works. When I was at the SEC in the enforcement division, when I was in the enforcement division, I obtained a 10-day trading suspension. So I knew how it worked from the other side. I knew what the issues were. I knew where if they did something procedurally along the way that was problematic, how to attack it. And I did that at every possible juncture. My approach, even to challenging a trading suspension in the first place, was not a passive, oh, we want to fight it, get it on file. It was with a real aggressive, not only are we attacking the merits of the trading suspension, we want this whole thing resolved within 10 days.
Yeah.
And whenever the SEC pushed back, I pushed back harder.
So speaking of, first off, I don't know if am I allowed to say congrats?
Yeah.
Well, I don't know if I say that.
Yeah, well,
is that appropriate? But when you do something for a first time period, like that's, you know what I mean? That sets a precedent.
It is precedent setting.
Yeah.
And actually, one of the arguments I've made is, aside from the fact that from a merits perspective, I truly believe this was the right result.
Of course.
In other words, to have it set aside. But at the same time, one of my arguments was this actually not only is it the right result, but it's a good result for the SEC. Because since you've never done this before, this case now becomes an example that you can hold up and say, we have previously now set aside a trading suspension, so there is precedent for doing so. Unfortunately, they didn't really give all the reasons for it. If you read everything that I filed, I think it's pretty obvious as to what were the persuasive arguments. But I think it was a combination of truly understanding the process, believing in the company working with me to give me the ammunition that I needed to be able to make the arguments. And while I appreciate the congratulations, to me it's also, and I acknowledge this to the company's press release, congratulations to the company.
Of course to the company.
And I say that because a lot of companies are unwilling to commit the resources. And they'll basically just step aside. They'll take it without really thinking about the long-term consequences, where essentially the company is saying, we're finished.
That says a lot on their part, though, because they're to step out and do that, understanding what they were up against, that it hadn't been done before.
Right. And as you can imagine, as part of that, as we were going into year 1, year 2, year 3, year 4, it's like, how much longer should we do this? Because it wears you down. But they were very receptive to my confidence in the merits of their argument. And it's not just the SEC. At one point, I went to the United States Court of Appeals to ask the Court of Appeals to order the SEC to act. So, but again, that was all part of this 4.5-year story of the trading suspension.
And you also, let me make sure my notes are right here. You also successfully sued the PCAOB recently?
Correct. We had a very successful year this past year in terms of our regulatory defense practice. And what that was about was the PCAOB, as part of one of its investigations. PCAOB is, and as your viewers likely know, are the regulators of public company accountants. So if a CPA firm is registered to be able to do the accounting work for do audits for for an issuer, they're regulated by the PCAOB, which has its own enforcement arm. And what happened in that case, very briefly, was they had conducted an investigation. I challenged their basis in the confidential process, their basis for bringing a case. We did not reach a settlement. As a result, they said, we'll see you in the litigation forum. Instead of going to the litigation forum, the next thing they did was issue a new subpoena, or their equivalent of a subpoena, at which point I sued them, claiming that their entire investigative process was constitutionally defective. And we had a jurisdictional battle where we filed it in Texas because the John Doe Corporation, because since it never became public, we still refer to it as John Doe Corporation. That was the domicile of that corporation. And the case moved to D.C. We got it moved back to Texas. I went up to the Court of Appeals not once, but twice. Rarely does a Court of Appeal issue what's called a writ of mandamus, where it orders a court, where it orders another court to do something. We were successful on a writ of mandamus. I went up a second time on another writ of mandamus, at which point the trial court judge said, not necessary anymore. I'm going to take this case. And then in the coming weeks, the PCAOB closed the investigation without action. So it was a complete win for the client, who was thrilled. And that was also first time anyone's beaten the PCAOB in court litigation.
Man, it's good. It's good. It's good. Good to catch up with you today and good to get these updates. I appreciate it. One other thing I want to bring up to you, MicroCap Conference. Those that aren't here this year, those that don't know what it is, why should the publicly traded companies attend? Why should even the service providers that support these publicly traded companies, why should they come? Why would they be here?
They're here for multiple reasons. Some are here to raise capital. Some are here to get a feel for what is the market. Some are here to benefit from the educational programs that are run by, that are very much part of the program.
Yep.
And others are here to build their network for the future. So, I mean, really, and that's on both sides, both the companies and those who are raising capital. They're looking for exciting new companies throughout the room in which in which we're sitting right now. And for the service providers, there are a number of quality service providers here, and they're here to make their services available to the companies and others who are here.
Awesome. Jacob, last thing I want you to do, look into the camera. If people want to follow up, if they want to learn more about your practice and your work, how do they do that?
Well, they can always connect with me on LinkedIn because I try to post our good results on LinkedIn. But beyond that, the law firm is Dickinson Wright, Dickinson Wright, where my email is jfrenkel, Frenkel, @dickinsonwright.com. And my office telephone is 202-466-5953. And I'm certainly most appreciative of the opportunity, not just to meet you in person and speak with you again, but to have the opportunity to talk to your tremendous following.
Yeah, absolutely. Thank you. And to the audience, just so you know, we'll definitely put the links in the show notes so you can just click on them and head out and check out Jacob's profile and also the website. And speaking of the audience, if this is your first time with Mission Matters and you haven't done it yet, hit that subscribe or follow button. This is a daily show. Each and every day we're bringing you new content, new stories, new ideas, and hopefully new inspiration to help you along the way on your journey as well. So again, hit that subscribe or follow button. And Jacob, man, thanks again. Appreciate you.
Adam, real pleasure. Thank you.